All right, I'm going to call in.
Welcome to the teleconference service. Please enter your access code, followed by the pound sign. To join the conference as the host, press star. Otherwise, press pound. The host has not yet arrived. Please stand by. Your conference will begin momentarily. Please continue to hold. Your conference will begin momentarily. Please continue to hold. Your conference will begin momentarily. Please continue to hold. There are 5 participants on the call, including you. You are now being joined to your conference. For a menu of available commands, press star pound.
Hi, it's Sarah Shake.
Hi, good afternoon. It's Bill Burns.
Hi, Nina Rossi.
Dan Leonard.
And good afternoon. This is Judge Pelios. Sorry, I normally introduce myself, but you all took the bull by the horns and did a wonderful roll call. That's usually what I would ask for next. I figured I'd let you finish. So thank you all. And thank you for being available on short notice. And for your patience, as you know, a good number of our staff are still working split time and remote, and sometimes they're in the office, sometimes they're not in the office and don't have full access to the networks and whatnot. Sometimes identifying the individuals who need to be reached. I was on vacation last week. I came back yesterday to a flurry of correspondence that only, as I worked through my inbox yesterday, that only grew this morning. And so I knew I wanted to try and speak with you in advance of tomorrow. And of course, it was a day that my assistant had limited access to her to the network at work, and so trying to get a hold of everyone was just was a bit of a task. And so I thank you all for your patience, your understanding, and your the assistance each of you provided in helping get this accomplished for today. Thank you very, very much. And so I guess I know we had a conference back on June 30th. I know we had agreed that tomorrow was going to be a hearing date. I know I had received a correspondence from Ms. Rossi in July explaining requesting an extension in a delay, citing to providing responses or issuing requests. I know it was citing to medical reasons, and I don't recall if I sent message back that it was approved, or if, given the nature of the letter, said it unless I hear otherwise. And it was, I know, as was pointed out in Ms. Rossi's correspondence at that time, that at the time of our June 30th call, a medical emergency had just presented itself. It ended up being a very long standing that ultimately culminated in the middle of August with the death of the individual. And so I know I was doing my best to be as responsive as I could, but to the extent that your correspondence may have said, unless I hear otherwise, I'll assume it's okay. And so I don't remember fully if I had sent word back that the extension was okay, or if I just didn't respond in the absence of any written opposition or anything of that nature. And so I guess that was it. And
I just assumed it was okay. So I sent it discovery request out.
So I guess we fast forward, and again, I guess improvidently on my part, I took vacation last week, and it seems a lot of things sprung to life, and due to perhaps in part owing to the times that we are living in, maybe everyone doesn't have the best ways to communicate with everyone, but I also saw a lot of one-sided communications directed to my office. I'm sure the attorneys on the call know that that's a no-no, and I, certainly don't want to suggest that any non-attorneys on the call don't familiarize them with themselves and may not be aware. But I know times are difficult, and everyone's doing their best to make sure that their communications and their needs and whatnot come directly. At least we hear about them. But it certainly does make things more difficult when not everyone is seeing everything in real time and being copied on communications to the tribunal. And certainly as I was on vacation, I was not in a position to help distribute them or respond to that, or even offer a correction saying, please do so. So, just to sum up what I said, excuse me, thank you. Sum up. I saw a series of emails within the last week. Mr. Leonard initially had emailed into the clerk's office requesting that the matter be converted to an in-person conference, and I see that you were advised by the clerk's office that the Office of Administrative Law is just not doing that right now.
Yes, Your Honor.
And I also saw that there was somewhat of an explanation for the response to Ms. Rossi's letter that was sent late in August, seeking a follow-up on the discovery, part of which indicating that you had nothing else to offer, part of which also indicating that you had never received the request. I then also saw that there was a subpoena served on employees of the school district. I believe these were the individuals that Ms. Rossi had identified in her earlier correspondence that she would be calling. And Mr. Burns, I don't know if you're their personal representative, if you're the board's attorney, or some combination thereof, but I see that you got involved as representing the witnesses and seeking a negotiated time for their testimony to be offered. And I know that you had no, that Ms. Rossi was okay with that, but I didn't see anywhere initially. And then I see that Mr. Leonard indicated that he was not available, although the initial communication, the email itself, it was unclear as to whether or not we were seeking to start the hearing at 3 o'clock or just those witnesses' testimony. Your subsequent letter certainly cleared that up. But that Mr. Leonard is not available at 3 o'clock. And then I received Mr. Burns' correspondence this morning joining Ms. Rossi's request for an adjournment of tomorrow's proceedings, or in the absence having a case management conference, indicating that you're in conversation trying to limit the need or the scope or the scope of the testimony, as well as but it was also in response to an adjournment request from Ms. Rossi, which you attached, which for whatever reason or not did not get to me through my office. And so I only saw that request as the attachment to Mr. Burns' address. So it sounds like we got ourselves quite a circus here. I don't mean circus in terms of in terms of anyone's acting untoward. Everyone's doing their best in these difficult circumstances, but it just sounds like we got a lot of bowling pins in the air at once right now with the juggler here, and so I just thought I would give it a try to get us on the phone today. I think without passing any judgment on any other request that was indicated in any of the correspondence at this point, I think the suggestion of a case management conference was a capital idea, and so that's what started our fire drill and getting us all on the phone today at this point in time. So that's my mindset in getting us all together here at this point. So Ms. Rossi, I believe that was you who was trying to be heard a few moments ago, and I apologize. I just wanted to get through my opening summary of where I am, so I did not mean to speak over you, but I just wanted to get my thoughts out. Was there anything to say?
No, just the only thing I wanted to say is that you were talking to the attorneys and said you were concerned that we weren't stopping people, but everything I sent to you, I sent certified regular mail to Mr. Leonard, and I do have the return receipt from the discovery request that he's saying he didn't receive. And it's information within his knowledge that I need. Then he said there's nothing he can add, but it's information within his knowledge that will assist me in proving my case. They're not complicated questions or requests.
Well, I certainly didn't say that every court communication was not copied to everybody. I just said that there were a lot of communications in the last week that were not copied to everybody, including your letter in which you said you did not have any means other than regular mail to reach him and asked that we get the request to him. So that was my only point in saying that there was a lot of correspondence in the last week, which was not provided to everyone on the call. And so I just thought it was important to make sure that, and similarly, I don't know that you had the benefit of Mr. Leonard's emails to the clerk's office.
I did.
You did or you did not?
I did not. Yes.
Yes, exactly. So it's now, I wasn't certainly singling you out or pointing fingers out or saying that every communication. What I am saying is that there were a number of communications from many quarters in the last several days that I was concerned that not every party was aware of. And so that was my only point in saying that. So, going in no particular order except the order that it comes into my head. Mr. Leonard, I think I took from the rest of your communication that you were while it was not your choice, you were accepting or at least acquiescing on the point of an in-person hearing. Is that correct?
Your Honor, I have a ton of paperwork, and for me, I'm somebody who likes things written down. I don't like a lot of communication because I like everybody in the room with all the documentation so we can pass it around, all see the same stuff. I've never done a Zoom hearing, but I do have a lot of paperwork that I would feel more comfortable with if I can show you in my defense of, a lot of different correspondence, a lot of different, things. And it's hard to do in a Zoom hearing. And that was my only problem with that.
Sure. Okay. Well, one of my judicial mentors, I guess I'll just start by saying I certainly understand that. There's not a lot that I can do about that.
I understand.
The Office of Administrative Law, as of today, is still not offering in-person hearings. And there's no promise as to when the Office of Administrative Law will be able to offer any in-person hearings. And I suspect that when we do start offering them again, it's not going to be like a light switch where we just turn it on and we say, okay, guys, everybody starting tomorrow, everything's back to normal, every courtroom will be full. I suspect there'll be a triage as to which cases take which priority in terms of if we're only going to be operating at some degree of capacity. And while, I certainly don't want to minimize, and this sounds snarkier than it is. It's not intended to be snarky. But look, for purposes of this phone call, this is the most important case on my docket right now because it's the one I'm focusing on. And it's the most important case at the OAL because it's the only one we're talking about right now. And certainly it's, when we're dealing with pro se litigants, I'm assuming most of the people on this call don't have a lot of other matters pending before the OAL. And so this is the only matter you should care about. But I don't certainly get to make the decision if there's going to be a triage applied when we do start opening up for some in-person hearings. I'm not the decision maker on that, and the decision makers may look at it differently. They may look at a person facing imminent homelessness or a student with disabilities who's trying to get an individualized education plan in place, or just different cases that are before us. There may be there may be a different perspective as to which cases are to get the priorities. And so I really can't promise anyone at this point in time that there's going to be an opportunity for it. And again, that's not to diminish anything you said. I had a lawyer on a conference call, a similar conversation with a call involving 6 lawyers. And as one of them very succinctly put it, in-person is preferred. In-person is what we know. And that's it. And certainly, I can't disagree with that. And I certainly can't begrudge you what you very clearly expressed in your comments now. But just understand that I can't offer you that.
I understand, Your Honor.
And I don't know when I will be able to. Okay. Now, but one of my mentor judges said, look, if you can maybe upset everybody a little bit, maybe you're coming at it from the right angle. And so, as opposed to a right angle for any trigonometry freaks out there. You expressed your concerns about documents and papers, and even in some of your correspondence, you've indicated that there was that the allegations are easily disproven, and certainly that rang a bell in my head as to whether we're talking about paperwork and documents and things of that nature as well. I spent a lot of time getting on this phone call, basically lamenting a lot of actions by a lot of people, and I'm going to lament some of them by myself. And we do have an omnibus order for the conduct of Zoom hearings. That while it's available on our website, perhaps I should have taken the initiative and sent it out to the parties to make sure you can review it. But on top of that, I know in some other matters I've issued a supplemental order that outlines some time frames and some issues as to how we can handle documentary evidence. And while I certainly take from your other email, Mr. Leonard, that this matter has gone on long enough and you're ready for it to be concluded, I can't help but wonder that, if perhaps Ms. Rossi's request for an adjournment, certainly coupled with Mr. Burns's request for a different timing of the witness availability, which seeks to have their testimony at a time that you're not available. And just to be said, I hadn't made up my mind to anything when we got on this call. And certainly I do want to proceed with a case management conference, and I want to have an understanding as to how many witnesses we are looking at. And I will remind everybody that the Office of Administrative Law can't enforce a subpoena. And while certainly I could flippantly say go to Superior Court if you want enforcement, on the other hand, certainly Mr. Burns trying to produce the witnesses that are requested and working to make sure they're available is something that we generally will try to work with. And so just looking at all these different issues, and as hesitant as I am, because I try to be a good soldier judge here, and I'm sorry, Mr. Leonard, I know you're a veteran, and the other veterans on the call. I don't mean to use the word soldier so flippantly, but I try to be a good employee of the OAL and try to make sure I get my cases heard, and I try not to adjourn cases, especially in light of last-minute requests. But certainly, I think that perhaps if we were to do a short, and I underscore the word short, adjournment, that might be the easiest way to address some of the concerns that everyone has expressed here, including, there'll be instructions about how to submit the documents that you want everybody to be looking at. And so we can do them on a Zoom hearing. And if we need to, we can familiarize ourselves with the process that we can all be looking at them if we've all been provided them ahead of time. And I can also share them on the screen during a hearing. And just maybe a short, and again, emphasize short adjournment may help address some, if not all, of the concerns expressed by you, Mr. Leonard, by you, Ms. Rossi, and by you, Mr. Burns. That maybe we can work something out. Is that something we can maybe try and find an agreement on, or?
I'm fine with that, Your Honor.
Oh, that was Mr. Leonard?
Yes.
Okay.
This is William Burns, no objection. I think that's a great idea, Your Honor.
Okay. Ms. Rossi, it being your.
That's good with me, Judge.
Okay. All right. So,
Your Honor, may
what
I
I'm
ask
going to
one-
ask.
Oh,
Sure. Who was that? I'm sorry. Was that Mr. Burns or Mr. Leonard?
It is.
I apologize.
And this is Mr. Burns, and I just had a quick housekeeping question about it. Not to belabor any of these points, but there is and I spoke with Ms. Rossi about it today earlier because I believe your judicial assistant, Ms. Lugo, asked me to reach out to Sarah Sheik. I jumped.
Sure.
Yes.
I don't, if you could, I don't have any information from her or from, related to that complaint. I only have Ms. Rossi's, complaint. If we could forward that to me, or at least some contact information, so if I have to write any further correspondence to the court, I can include,
Sure.
this sheet as well.
No, that's right. And I think, and I believe Mr. Leonard's summary, when you had requested on the email, my assistant provided me the email conversations trying to get this together. And I think Mr. Leonard provided a somewhat of a summary. You know, Ms. Sheik also had filed a complaint, and I believe they were handled in a joint matter at the commission, and they were transmitted together. I don't think these are consolidated matters at the OAL. I think they were transmitted as one matter. And certainly there was some conversation at our earlier conference as to whether or not Ms. Rossi would be taking the lead in presenting the case. But I do believe that also, as Mr. Leonard indicated in his email to you, was not necessarily, I think we had talked about perhaps getting a writing. And I don't see one here in my system. Again, we're all doing our best while being remote. But as of right now, I don't think I received that. And so Ms. Sheik, who I believe is on the call at this time, also, is basically like Ms. Rossi is a complainant in the matter. Certainly, I guess we can, do our best to exchange the information with each other. If I may, I am looking at the last email that was sent with dial-in information, and I see Mr. Burns, I see you and your assistant on that email. I believe I see an email that starts as mssarahsheik@gmail. I see an email address that identifies Ms. Rossi, and I see Comcast Maine, which I believe
That's me.
is Mr. Leonard. So that's the DPL 1976 at Comcast.
Correct, Your Honor.
And so I think that last email, I think you're all on that email. And so,
Great, thank you.
treat that as gospel. Treat that as gospel going forward for serving. I mean, certainly to the extent I'm not telling anybody not to do anything hard copy where practicable, but we generally ask for even with hard copy, like hard copy with electronic copy. And so, if we just use this as our service list, along with my assistant, Maria Lugo, to the extent when it's appropriate, when you, certainly I expect there'll be communication between you all that I don't need to be a party to. And that it may not be appropriate for me to be a party to, and that's fine. You can keep Ms. Lugo off of those emails, but when it's something that is coming to me and you add her, just use the same service list. And I think that'll solve most of the problem. And that certainly is not to say that there may be some practicability and practicality to other forms of communication. So if you do want to exchange additional contact information, please feel free to do so now or in a follow-up email after this phone call. And the other piece of that is, any communication from the last couple of weeks, whether it was, and again, Ms. Rossi, you acknowledged that you didn't have time to get it to Mr. Leonard, whether it was this morning or yesterday that you sent it. That communication, as well as Mr. Leonard, your emails to the clerk's office, if you still have them, if you can all just basically share them with each other, just re-forward them to everybody on this list so that everybody's got the same cards, that they're looking at before we come back together. I would appreciate that. So, can we do that?
Yes.
Judge Nina Rossi, I certainly will.
Okay.
I will, Your Honor.
Mr. Burns.
It's Mr. Leonard.
Yes, Your Honor, I'm sorry, William Burns. Yep, no problem with that.
Your Honor, Mr. Leonard here. I have just one question. I understand Ms. Rossi has questions pertaining to matters with this case that I didn't receive. If she has a proof of service to me, I would like if you can scan that and so I can see it, because I never received it. Nobody in my family received it.
And maybe, and look, maybe we go one better, and just to try and avoid getting to the extent that we are, let's also look at this as a bit of a reset button. I don't think that Ms. Rossi at any time has suggested that you'd be barred from producing anything yet. I don't think she's asked for any particular sanction. She asked for an adjournment to try and see if she could get the information she needs from Mr. Burns. And so I don't know that anyone's really trying to prevent anybody from submitting anything at this point. So, I mean, certainly if you can provide that, Ms. Rossi, that's great. But why don't you also, by way of this email with copy to everybody, resubmit your discovery request? And Mr. Leonard, you know, if you do your best to respond to it timely, and we'll see where we are.
Your Honor, can I ask one question in reference to that?
Sure.
So on January 22nd, I received a letter from the School Ethics Commission from Kurt Schwartz, Deputy Clerk, Office of Administrative Law, where it states, pursuant to a couple statutes, the complainant has the burden of to factually establish a violation in accordance with the standards set forth in the regulation. So by reading that, Ms. Rossi has the burden of proof that I violated a statute of ethics. So here we are, a year and a half, maybe close to 2 years from the time of posts that I made on social media, I may not have made on social media. And I told the Ethics Commission, in great detail, elaborate detail, it's all documented. I'm sure it's somewhere at your office, how I responded to all of her complaints then. And I really have nothing else to offer because I know this isn't legal, it's administrative. And whatever I'm used to the term taking my Fifth Amendment because I don't want to answer anything now or say something now in my capacity as a total civilian, where I'm more apt to say something now that I'm not an elected official, and I just don't want to say anything that's gonna add to her case, my case. So that's my only concern is.
Okay. Well, and I certainly understand those concerns. And I apologize. I don't mean to necessarily assume that just because somebody is pro se that they are or not an attorney. You are not an attorney by training at all, Mr. Leonard?
I am not an attorney.
You are. Okay. So, because and even still, certainly people who are not attorneys can have a very high level of understanding of these proceedings and whatnot too. And so if I come across as over-explaining, it's just because I just want to make sure that I'm doing my best to make sure I'm addressing your question. If it comes across, I certainly don't want to sound like I'm talking down or oversimplifying, so please forgive me if it appears that way. I just want to... So you're correct. The burden of proof lies with the complainant in a matter like this, number one. And I certainly don't doubt that you are telling the truth when you say you provided a whole lot of information to the Ethics Commission, who then transmitted the case here. The thing is, when a matter comes to the Office of Administrative Law, when it's referred to the OAL from the Commission, it comes over as a what we call a trial de novo or hearing de novo, and that's just a fancy Latin way of saying it's all new.
Oh, okay.
And we're not relying on what was provided before. We're not relying on what was said before. We're not, because certainly you may have appropriate objections to make to certain disclosures or things like that, or Ms. Rossi may, or Mr. Burns may on behalf of his witnesses. And so we're not going to muddy the record up. We're going to play by the rules of the Office of Administrative Law. And so that's what we're going to do. And so while it may feel redundant, it may feel like we're pushing the boulder up the hill again for a second time, even though you can see a perfectly good boulder sitting there at the top of the hill still. We sometimes run the risk of repeating ourselves. So long-winded way of saying that what you provided to the Ethics Commission, I certainly don't have the benefit of it. And while Ms. Rossi and Ms. Sheik have the burden of proof in this matter, that certainly doesn't mean that if there is information exclusively in your control that may or may not help your case or help their case, that they're not entitled to ask for it and that it gets exchanged.
Okay.
And while I certainly understand the length of time that has gone on in bringing this matter to this point, the truth of the matter is discovery in its normal goings-on at the OAL is not really required to be completed and everything exchanged until almost 10 days prior to a hearing. And so we try not to do that because then we get in the way of screwing up hearing dates and stuff like that. But certainly, and responses are expected within 15 days of a request being made. So, and as far as the Fifth Amendment goes, I mean, these aren't criminal proceedings per se. I don't know if there's concern or worry about a collateral criminal investigation or anything of that nature. And if so, that's certainly a different situation that we can address often when those matters are at issue. We even delay proceedings until a criminal investigation is done. But, certainly that's not to say, and I'm not here to offer you legal advice, but that's not to say that there may not be appropriate objections that you can make to certain discovery requests as well. But you need to affirmatively make them, And I guess the sanction that ultimately comes up is if you've got you're talking about documents that you may intend to rely on, or that you have papers that you want to hand around, and if we were in a live hearing, those need to be provided to Ms. Sheik and Ms. Rossi, and I guess as courtesy to Mr. Burns as well at this point as he's prepping his witnesses. Although arguably that may be on the individual calling his clients, but since we're all together on one email list, I see no harm in just sharing. So
I can tell you, Judge,
excuse me. And so if there was something that you were intending to rely on, that's something that would need to be shared anyways in advance. And if those are the same documents, if what you're looking to provide are responsive, and I know Ms. Rossi represented that some of it goes to your knowledge, if there's an objection to be lodged, you can. But I guess the long and short of it is, if you don't respond, if there's a document you have or testimony you have that may be responsive to the discovery request, and you don't share it ahead of time with Ms. Rossi, and then you seek to assert it in your defense, surprise is only for TV lawyers. It's not for the real world. And so, Ms. Rossi may ask that you be barred from submitting something if she feels that it was responsive to her request and it wasn't provided. And so the safest way to make sure that you get what you have to say in is also to share with each other ahead of time as well. So anyways, long-winded answer to your question, but I just wanted to make sure I kind of, hopefully some of what I said addressed the concerns you were saying, or at least helped
yes,
to illuminate the process a little bit.
Yes, Your Honor. You had mentioned Superior Court earlier, so right away I thought of the Fifth Amendment because that takes it out of administrative, possibly to criminal. And if now that we're all on the same email chain, if Ms. Rossi would just email me the discovery request, whatever that is, then I will confirm receipt of it through the email so everybody can see that I received it. And then anything that I'm going to use in my defense, I will also email back. I'll email it to everybody.
Yes, and certainly that anything that you intend to use at the hearing should be emailed to Ms. Lugo, as well. Copy to each other. Everyone should receive it. But that's an instance where Ms. Lugo should be on that list, because I should be able to be looking at them during the hearing as well.
Okay.
And that doesn't mean that someone can't object to something, and if it's objected to and the objection is sustained, it won't be considered. But just as an administrative practicality, we're just asking that all documents that people are expecting to rely upon at hearing be submitted in advance, and that if there's going to be a real strong objection that you can't live with my knowing what does or doesn't get counted at the end of my rulings, then you do what's called a motion in limine ahead of time. But hopefully we don't need to get to that. So, okay. All right. Now, Ms. Rossi, were the two individuals represented by Mr. Burns the only witnesses you intended to call, or did you have other witnesses that you were intending to call?
No, Judge, those are the only two. And I just want to... Including yourself, or do you anticipate offering testimony as well? No, including
Okay.
me, right.
Okay.
But I just
And
want to
Ms.
appeal to the court and Mr. Leonard.
Go ahead, please.
No one has implied or is implying criminal conduct here. That's never been part of this case.
And,
No,
and I only just raised that because the Fifth Amendment was mentioned, and I said that it may not apply here, but sometimes we do have cases. Just to give you a very tangential example, is sometimes we have administrative motor vehicle license suspensions that involved an accident with a fatality that there's still an ongoing investigation. Sometimes the Motor Vehicle Commission works more swiftly in trying to impose a suspension than the prosecutor's office may in a investigation. And so we find ourselves on the cusp of a hearing where there's still an open criminal investigation going on. And so I just wanted to just cover myself because I had said that there was not a criminal, that this was not a criminal proceeding. But certainly we do sometimes have to make allowances for that. But yes, so my understanding is no one is making any such allegation or concern here, but not having the benefit of the entire file in front of me, or I suddenly realized that I may not know if there were or there weren't. So I thank you for clarifying that.
Sure.
Ms. Sheik, I know there was some discussion as to whether or not Ms. Rossi was going to be driving the case in particular or not. Did you anticipate having any other witnesses testify beyond, including yourself, beyond
no.
the two that Ms. Rossi has identified? No. Okay.
No, I am not. Yeah.
So we're just
She is
looking at
driving.
the-
And she is driving the case. Sorry.
Okay, that's fine. And then, Mr. Leonard, are you anticipating calling any other witnesses other than yourself, or even calling yourself? I don't. Right? Do you anticipate being the only person offering testimony on your behalf, or do you anticipate calling other witnesses?
I need to see the discovery request from me before making that decision, but right now it's just me.
Okay. So right now we're looking at likely 3 witnesses total, unless there's a lot more to what's being understood or alleged here. It sounds to me like this is a one-day hearing at best. Certainly I understand your caution, Mr. Leonard, that you'd want to see the discovery request, and if other witnesses' testimony may be required to be responsive or something of that nature, that certainly is fair. So, now ordinarily, when somebody gets a discovery request, it is expected to be responded to within 15 days. Ms. Rossi, I assume, will exercise all diligence in providing a new copy to you, Mr. Leonard. Is that something you feel you'd be able to get your responses to her in? Is that?
If she emails it to me today, Judge.
Again, yeah.
If she's
15 days from when you get it. I should, not 15 days from today, but 15 days from when you get it.
If she emails it to me today, yeah, 15 days is fine from today.
Okay. But in any event, 15 days from when you get it. I'm sorry, Ms. Rossi?
There's only 14 questions. It's not worth.
Okay. Okay. And so those would need to be provided back. It's supposed to be done 10 days in advance. And I know Ms. Rossi wanted to have the benefit of that discovery and opportunity to speak with Mr. Burns. So 15 days is 23rd. 10 days after that would be... How do we feel about Tuesday, October 6th as a potential hearing date?
I'm checking now, Your Honor.
Thank you. I'm sorry, Mr. Burns?
I can confirm one of my witnesses, and I will just need that day's probably fine, but I can confirm with one of them if you need about 2 minutes.
Okay.
Your Honor.
It's fine with me, Judge Nina Rossi.
Dan Leonard, me too, Your Honor.
Fair shake, it's fine with me too.
Wonderful. So,
Judge, what was the date we were looking at again? I'm sorry, I slipped over.
it's okay. Tuesday, October 6th.
That is fine with me, Judge.
Okay. And, you know, obviously, if there, I think we'll be fine going at 10 a.m. As we had intended. If there is now certainly to the extent that Ms. Rossi and Ms. Sheik are only planning on having testimony provided by Mr. Burns' clients, hopefully they can be available at 10 a.m. on that date. But the only other witness right now that we'd be expecting to hear from would be Mr. Leonard, and certainly I think in fairness, as where the burden of proof lies, it's probably best to keep Mr. Leonard's testimony until after the witnesses. And so if there's a time issue, just circulate it on the, and we'll just plan. And normally we block out an entire day for a hearing. So I'm free anytime during the day. If all of you can work out with each other an agreeable time, but I'd like to start the hearing at 10 o'clock if possible. But if 11 is only going to work for both of the witnesses, if one's available at 10 and the other at 11, we can work with that, and we can start and take a break and resume. But right now, we'll plan to notice the hearing for 10 a.m. on October 6th. I'm going to ask that any documents or exhibits that any of the parties intend to rely on during the course of the hearing, I'm going to ask that be provided no later than September 30th.
That's fine, Your Honor. Dan Leonard.
Ms. Rossi, Ms. Sheik?
Sure.
That's fine.
No problem.
Okay, great. And I will also ask Ms. Lugo to forward, and again, if you go to our OAL website, the Office of Administrative Law website, there is an omnibus order that talks about the conduct of Zoom hearings. And I may issue a supplemental order in addition to that, but it will just basically talk about the timelines that we spoke about here. Basically talking about you can't record or live stream, the proceedings, things of that nature. You can't have different screens going in front of you. Now, if your only copy of the documents are PDFs, we just announced that at the beginning, and that's fine. I'm not going to punish you for looking at a PDF that you were emailed if that's the only way you got the exhibit. But just generally speaking, we're trying to recreate as much as we can of an actual court proceeding. You shouldn't have somebody else in the room with you, unless you're sitting with, an attorney that's representing you, things of that nature. But, if you want to, rather than waiting for us to send it to you, if you want to go to the website and take a look at the omnibus order, that's fine. We can do, you might want to get a sneak peek, to help familiarize yourself with what to expect. And you'll receive a link like you did, with the Zoom login, and you'll be admitted. Once I'm logged in, you'll be admitted. You don't need a Zoom account. All you need is the link and the software, and it'll bring you to our hearing room, and then I will admit you once I am logged on. And kind of like I did for this conference call, don't panic if it's 10 a.m. and you don't get admitted right away. I know some people have tech problems or call-in problems, or I generally wait 2 to 3 minutes before I log in just to give everyone else a chance to be there, because again, it's just probably best that even though you'd be in a waiting room, it's just I try to minimize conversation directly with one party when the other isn't present. So I usually wait a few minutes before I start seeking to admit people into the hearing room. Okay.
Yes, Your Honor.
Are there any questions for me?
Your Honor.
And of course, it goes without saying then that tomorrow's hearing is adjourned. Yes, Ms. Rossi?
Yes, Judge, I'm just a little confused. When I send the discovery requests, should I just send them to Mr. Leonard or to everybody?
You know,
I'm going to respond that I received
this
it.
is probably, I'm sorry, Mr. Leonard, what was that?
When Ms. Rossi sends me that, I'm going to immediately respond to her that I received it, so that way she has a copy and that I am in receipt of whatever she sent.
No, that's not the reason, Mr. Leonard. I'm just confused because earlier the judge said we should copy everybody on all communications, so that was my question. Should I copy everybody or send, usually, I just send them to the person answering them.
You know, it's, I'm not going to say you need to send it to everybody, but to the extent that, to the extent that you have a co-complainant, even though she says that you're driving the case,
Okay.
it's probably good if Ms. Sheik have a copy. It's probably good that, if, whether or not you need to provide it to Mr. Burns, again, you're working with him and prepping witnesses that you call. With no disrespect, Mr. Burns, I'm not as concerned, about that because the portal into the case is through that relationship. But just to the extent that we've had some amount of people saying they haven't received things or have received things, again, I'm not making a judgment as to whether I believe anybody or disbelieve anybody, but certainly to the extent we copy everybody, it certainly takes those concerns out of the equation. So look, if you send it to him and he responds to you that he received it and he sends you responses, then we have no problem. But if we find that there is a problem and that there is an issue of whether they were sent or received or not, if you don't hear back in the 15 days, or Mr. Leonard, if you don't receive the request in a couple of days from now, then maybe you should send a response to everybody with a copy to my office that it hasn't been received yet. Because, if we've got to try and figure out if someone did or didn't receive something, it just seems to take that off the table if we're copying everyone. But if you feel there's a reason that someone would be prejudiced by circulating that, I'm not going to tell you how to conduct that part of it. Just understand I'm not looking forward to having to litigate questions of whether or not people ever receive things in the first place or not. So that's all. Yeah.
Okay. Thank you, Judge.
No, of course. Any other questions for me?
Your Honor, I have 2 questions left. Mr. Leonard.
Yes, sir.
So on the 6th, since I'm not familiar with the process, Ms. Rossi's going to provide her case, and then I'm going to go second, and then I provide an opening statement and then start presenting my rebuttal or evidence. Is that how that works?
Well, almost exactly right. The opening statements we will do before anyone presents a case.
Okay.
It's not under oath. It's not your testimony, but if it's what you intend to show, I will offer the parties to offer opening statements at the very beginning. Sometimes parties waive opening statements. We don't have a jury. The testimony and the documents will show what the testimony and documents will show, and you'll be able to argue in a closing statement as to what you feel the evidence showed. But some parties want to make an opening statement. Some parties want to waive it. I'm agnostic on it and generally get guided by the preferences of the parties. But that would happen first. If we are taking opening arguments, then we will have them, and after they are all completed, then Ms. Rossi would present her case, and obviously you have the opportunity to cross-examine any witnesses that she presents their testimony on.
Okay.
And then it'll be your turn to provide your testimony and call any witnesses you may be calling. And again, like with discovery or documents, if you're going to be calling any other witnesses, we should advise everybody of that fact by the September 30th date. Then you will do that. And then at the end, once everyone has had their cases presented, certainly to the extent that they have a case to present, if If Ms. Rossi or Ms. Sheik feel there's a need for rebuttal testimony, we will deal with such a concern or request at that time. It's usually the exception, not the rule, that we have rebuttal testimony in these hearings. And then once everyone's done, we can do closing arguments. Closing arguments can be done one of two ways. Sometimes the parties wish to proceed verbally, and they argue, this is what the evidence shows, this is what the law says, this is why you should find for me. Sometimes parties feel more comfortable doing that in writing and can make a request to do so. We don't have to decide that today. And sometimes we really decide that even once everyone's had an opportunity to present their case, if you already know that you're going to present, that you would prefer a written summation, you certainly can let me know at this time. But if you don't let me know, it's a question I will ask at the conclusion of testimony, because sometimes we may go into it thinking that an oral summation will be more than enough. But once we hear the case, we may feel it's a little more intricate or complex than we had expected, and therefore we prefer to do it in writing, And so it's a question we can revisit again on the 6th. But closing statements will be done, either orally or by written summation.
Okay, I got that, Your Honor. And the second question.
And you said you had two.
Yeah. The second question, I just wanted
Your
to.
second question?
I just wanted to make a statement that I received everything else Ms. Rossi had sent. I just don't understand. I just don't know what happened to the. I was looking for him too in the mail. I just don't know what happened to that thing. And if Ms. Rossi has a return receipt, I'd like to see who signed it. But I did receive everything else she had sent, and there wasn't any other administrative problems with that. And I look forward to receiving her discovery request.
Okay.
So we will, again, I'm glad we were all available today, and as I said, the perfect example, I know that Ms. Rossi sent an adjournment request for tomorrow. I know that I only saw it. Because it was attached to Mr. Burns's joining in the request, That doesn't mean that Ms. Rossi didn't send it. In fact, I think it got emailed to me now during the course of this conference. I think I see it now in my email inbox.
Yeah.
But the point being, I certainly have, unless I have a reason to disbelieve anybody, I don't disbelieve anybody, And so the point being, we're hitting the reset button. I accept everybody's representations at face value. The most important thing is that we are going to have an opportunity to exchange all the information before we have the hearing. And I really commend everybody. I know this isn't being done in the exact manner that anybody would want it done. And you're all nobody is being shy about expressing their preferences. And everyone is being flexible in trying to work within the limitations of what we can provide in the reality of the situation we're in right now. And so I commend you and thank you all for that. And so, certainly know the information will be exchanged and we'll move from there. And, I certainly am not giving any thought to anything that came before at this point. So. Anybody else, any other questions?
Your Honor.
For me, Your Honor, that's William Burns.
Your Honor, Dan Leonard, while we were doing this, I saw Mr. Burns sent out a few emails that Mr. Burns's request for courtesy copy of all pleadings, that's going to be from your office, OAC office, or OAL office?
No, Mr. Leonard, this is Bill Burns. That was to the litigants. If you filed anything, I would just ask that if you either have an answer. I think I have your answer. Really, it's just, I believe Ms. Sheik's complaint. If there's any other pleadings that I'm not aware of.
Okay. I'm done, Your Honor.
Consolidated. Sorry, it's consolidated with Nina.
They did consolidate the complaint, so I'm not sure if the Ethics Commission did it or OAL.
The Ethics Commission did it late last year, and then they made a decision on one of the charges, and then the rest of them went to the Office of Administrative Law.
So if there's only one complaint and answer on those issues, then I disregard my. Well, thank you for the courtesy.
All right. Anybody, anything else?
I'm good, Ms. Rossi.
Okay.
I'm done,
So
Dan
I
Leonard.
look forward to speaking with Okay, oh, thank you. I look forward to seeing you all on the 6th. As we say, we'll put faces together with voices, and hopefully you take full advantage of the opportunity to have whatever conversations you need to have, exchange what information you need to have. Again, I'm just asking that anything that you intend to rely on at hearing be provided to everybody and to my office no later than the 30th. And other than that, I will see you on October 6th. Thank you, everyone, for your time today and your efforts. I really, really do appreciate it.
Thank you, Your Honor.
Thank you.
Judge.
Thank you.
Be well.
I am ready.
Fine.
Done.